No, Your Honor, he was on federal release and he's being.
When these allegations arose?
Yes, Your Honor, when these.
Motion for bond reduction denied.
Your Honor, if I may finish, please, briefly, if we may.
Go ahead, so I can just get to what I'm going to.
Part of his release was that he clear up his warrants. He surrendered himself voluntarily on.
He was on
February
pretrial
14th.
release when these allegations came up. They are capital cases, counsel. I don't know what you want me to do. Quite frankly, I think the bond's set too low.
Thank you for your consideration, Your Honor.
Don't get smart with me, counsel. That won't work well for you. Court does call the case of the people versus Pierre Jefferson.
Good morning, Your Honor. Mark Awad on behalf of the defendant, Mr. Pierre Jefferson, is present in court. Standing to my immediate right. Pierre Jefferson. Your Honor, we have had an opportunity to.
Your name, sir?
Pierre Jefferson.
Thank you. Go
We
ahead.
have had the opportunity, Your Honor, to have the PCC, and we are set to go to exam at the next available date. If I may briefly address bond.
Discovery ready?
Yes, Your Honor, discovery is complete.
I believe so, Your Honor. There might be some videos outstanding. I will look into that today and get anything turned over as soon as possible.
People have their witnesses available March 5th.
We will try to-
Preliminary examination will be set March 5th, 2024, 9 a.m. in person. That will be before Judge Perry.
Thank you.
Bond, briefly.
Yeah, as to bond, Your Honor, Mr. Jefferson is a lifetime resident of the state of Michigan. I do understand these are capital offenses he's charged with. However, the presumption of innocence must weigh in, and the bond that's currently set is tantamount to remand. He has insufficient funds to come anywhere near.
But it's to CSC first. He could be remanded without bond.
True statement, Your Honor. However,
I know.
However, we're asking the court to lower the bond.
Response from the people.
Your Honor, I'm going to request that bond remain as it is. The accusations in this case are incredibly serious, that the defendant was engaging in contact with the victim, who was a sex worker, and held a knife to her throat while he assaulted her. In addition, I understand he's on pretrial federal release for weapons offenses and fraud, and has bench warrants outstanding in the 15th District Court. So I believe bond is appropriate.
He was on federal release when
Your Honor,
these allegations came up.
Your Honor, he was on federal release and he's being.
When these allegations arose?
Yes, Your Honor, when these.
Motion for bond reduction denied.
Your Honor, if I may finish, please, briefly, if we may.
Go ahead, so I can just get to what I'm going to.
Part of his release was that he clear up his warrants. He surrendered himself voluntarily on.
He was on
February
pretrial
14th.
release when these allegations came up. They are capital cases, counsel. I don't know what you want me to do. Quite frankly, I think the bond's set too low. Motion for bond reduction denied. Thank you.
Thank you for your consideration, Your Honor.
Don't get smart with me, counsel. That won't work well for you. Let's call the case of the people versus Michael O'Leary.
Morning, Your Honor.
Morning, Your Honor. Michael Vincent on behalf of Michael O'Leary, who is standing to my right.
Yes, he is.
Your Honor, today's date time set for a PCC. We need a date for a preliminary examination.
Discovery complete.
As much as I know, it is.
Your Honor, and Mr. Vincent, you can contact me. We can further discuss it another day. You think is outstanding.
Oh.
Your Honor, there are a few things we do need to address. First of all, the victim in the case was in possession of defendant's passport. That has now been turned over to Mr. Vincent, so they are in possession of that. I just want to put that on the record. Furthermore, there is quite some concern that there have been attempts to call the victim from jail by Mr. O'Leary. So I want to make sure that those are addressed here today.
All right.
And if actually Mr. Vincent and I can approach.
Gonna take him a while, so yeah. Record should reflect we have a brief bench conference. I'm gonna pass this matter briefly to try to resolve some issues, so we can take it back. Thank you. Court does call the case of people versus Michael O'Leary. Recall.
Morning, Your Honor. Marie Tan, Assistant Prosecuting Attorney on behalf of the people.
Morning, Your Honor. Michael Vincent on behalf of Michael O'Leary.
You wanted this set for a prelim, correct?
Yes, Your Honor.
Did you? Yes.
Can you approach one more time, Ralph?
Okay.
Please?
Yes,
Thank
you may. Okay. Record to the effect, we've had a lengthy bench conference. I will set this for preliminary examination, trying to set it very quickly. I will take the case. We'll set it for this Tuesday, the 27th, 2024 at 1:30, and that is before me.
Your Honor, and if I may, just an issue I addressed at
Yes.
the bench, I apologize. I researched the jail call issue. I got some information from our intern and double checked a few different places. It appears that other inmates were using Mr. O'Leary's either PIN or account to make phone calls. There were phone calls made to the victim in this case, but we don't have anything showing that Mr. O'Leary personally called the victim's number.
Right. And there may be, so that it's also clear, because of the victim's employment, there may have been justifiable reasons for those individuals.
Thank you, Your Honor.
All right. All right. So the 27th, 1:30, bond continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Kevin Shametz. Jones. Ms. Hammoud? We're, oh, sorry to wake you.
Thank you. Tonight, I'm appearing written on behalf of Mr. Showamesh, who stands to my right. I was in a very enthralling conversation with Ms. Julian, and I apologize for making the court wait.
But go ahead.
Your Honor, today's time and date set for PCC in this matter. Mr. Showamesh would like to waive his right to preliminary exam. I've counseled him on the same, and he's executing the waiver right now.
Sir, is that a correct statement?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense is alleged committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, Your Honor. As to the complaint waive formal reading for the record, for the information, I mean, Mr. Showamesh stands mute. I ask the court to enter a not guilty plea on his behalf.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all counts. Pretrial will be set for
February 29th at 1:30 before Judge Slade Thursday.
February 29, 2024, 1:30, Slay Thursday.
Adjourn that one to the next pretrial date. Okay. Okay. And I'll come see you.
Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you for your help.
Don't start talking.
This is so fun.
Yeah, it's just a blast. Court does call the case of the people versus Tracy Vincent, 2 cases. Other side.
Oh, I just, thought you pointed over
No,
there.
I was asking him.
Oh, okay.
Ready, Judge? Oh, no, it's,
Prosecutors on Zoom.
Hi, and good morning, Your Honor. Chris Fleming, P75946, appearing on behalf of the people, special prosecuting from Lenawee County.
Thank you, sir.
Ready, Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Tracy Vincent to my right at the podium. Please state your name for the record.
Tracy, I was in the bench.
Day and time set for a PCC in this matter, Judge. I believe this is also a forensic evaluation we're waiting for that has not come back yet. They are trying to restore Mr. Vincent to competency, and I do not have a copy of any update. I don't know if Mr. Fleming had, I do not have.
It looks like the last update we received was from February 5th, indicating the time on 23F55048 has expired, but the time on 23F55044 has not as of yet. So I will
Got it.
leave I will leave it into the honor's discretion what we do with the 5048 case. But it looks like we're still waiting for admission on the 5044.
So it seems to me that the best move would be to adjourn both out unless
Sounds
there's
good.
an objection.
Sounds good to me, Judge. Mr. Vincent.
Remember we spoke about.
I'm doing.
Okay.
All right. Mr. Vincent does want me to make a request, Your Honor. Obviously, this matter was referred for competency. Mr. Vincent would like to have a hearing on his competency. Although I do not have any additional information to add, we have not done an independent evaluation, but he would like to have a hearing on that matter if the court would allow. I don't have any
Well,
additional.
we're waiting on one other report.
I understand that, Judge, but he wants me to request a hearing. I told him I would do that, Judge.
Your Honor, under the Michigan law 3302020, a defendant can only be determined incompetent to stand trial if they are incapable of understanding the nature and the object of the proceedings against them. My attorney can tell you that I'm
And
not.
can rationally assist in their
Yeah,
defense, which I don't know.
Exactly.
Which I don't know that you're doing right now, but go ahead.
Sorry, I didn't, but my attorney can tell you that even my attorney, Andrew Banners, back in April last year stated that I was not incompetent to stand trial. Police officers put in the report that I made statements that I was suicidal, that I wanted to get murdered, statements that I didn't make that could be found on the body cameras that I did not make. And it's false statements that was made that committed me to the treatment that I'm being sent to right now, which is illegal. It's also a felony under the Michigan law 750-410A. So I did not make any statements. I understand the nature of the proceedings against me. I understand the charges. I understand the preliminary exam. This is my first time in here. You know what I mean? And I just like to request a hearing to challenge the forensics.
On one of your cases, I don't have a report.
So he has to wait for your report, he's saying, for the second case that has not come back yet.
Right, but they've already said I was incompetent to stand trial, and I've been incompetent the whole time. That's what I'm saying. I've understood the nature of the proceedings the whole time. Even Andrew Banner said it back in April last year, and this is holding me up in violation of my Sixth Amendment right to speak.
Where are you going, Mr. Bannon?
If you can remember.
Obviously, Judge, I'm not a doctor, and either is Mr. Banners to my knowledge, but I have been able to communicate with Mr. Vincent, but I don't have any additional information to provide. I don't have an independent evaluation. I have nothing to offer in terms of evidence, but he would like to have a hearing on that issue otherwise.
Doesn't make any sense to do one and then the other report because I have no idea what that's going to say.
Understood.
So I'm going to adjourn the competency hearing. I don't have the report. And what I will do, and Mr. Vincent, listen very closely. I guess if you've read the statute, you understand how this works. I'm going to give you a date that's going to be in April. However, if a report comes in before then, it can be set earlier than that.
Okay.
It will be moved up. Understood?
Yes, sir.
I think he has one more request, Judge.
Okay, let me set the date and then I'll deal with the request. Go ahead. The hearings will be set for April 4th, 2024, 9 a.m. What's his other request?
You know, I think he wants to address this bond.
Go ahead. That's worked very well today.
I understand, Judge. He's been incarcerated, I believe, for over 7 months on this matter. 11 months on this matter, Judge. Obviously, he's still pending the forensic evaluation being completed, but he would like the court to consider addressing his bond. I do know his mother is involved in his life. She did come to his last court date to support him. We would ask the court to consider a reduction in his bond despite the pending forensic evaluation.
Response from the people.
Judge, these are very serious cases. He has quite an extensive record. People would request bond remain the same.
All right. His bond is set actually at a relatively minimal amount of 5,000 cash surety each case, given the nature of the charges. Motion for bond reduction is denied.
He's just gonna leave it where it is. We'll talk.
Thank you.
With that, the defense argued that the defendant deserved a lower bond, saying he voluntarily surrendered and had been cooperating with the court. But prosecutors pushed back hard, reminding Judge Simpson that the charges were extremely serious and that the defendant was already on federal release when these new allegations surfaced. The courtroom fell completely silent as everyone waited for the ruling. Then Judge Simpson delivered a crushing response. "Counsel, I don't know what you want me to do. Quite frankly, I think the bond is set too low. Motion for bond reduction denied." The attorney tried to speak again, but Judge Simpson immediately shut him down with one unforgettable warning. "Don't get smart with me, counsel. That won't work well for you." One powerful statement ended the debate instantly. Was Judge Simpson right to stand his ground? Let us know in the comments.